quorum, I do want to note, oh, there's the live stream. I do want to note that copies of the July 18th and August 11th meeting minutes have been posted to the task force website. So if there are any concerns, corrections, anything like that, please let me know. Hearing nothing, then I will declare the meeting minutes are approved. So last meeting, I think I know Gina, you were on vacation, but I do think with Josh and I, we got kind of just sort of a roadmap, if you will, for going forward as we're now talking about the remedies, because I think that's the big one. And I think there's just quite a bit that we want to try to cover, and maybe it doesn't take as long, but just wanting to make sure we covered as much as possible. And so kind of with that, of course, we're going to be looking at the reconsideration process, the bars, administrative accountability, and just kind of quite a bit. So, Will, I think you did note you're prepared to discuss the legislative history?
Yep. Thank you, Madam Chair.
Yeah, why don't we start there? I think that's a good starting point. And I'm going to pull up that 245C.24 as you're talking so that it's in front of me too.
Sounds good. So I think last time I gave sort of a confused off the top of my head thing, and I was both right and wrong about permanent bars in 245C. So permanent bars, in a sense, predate 245C being created in 2003. They date back to 1993 in 245A, which was essentially the predecessor, where the language was transferred over in 245 or in 2003. But those were bars specifically for, and actually I'm just going to pull up the language, family foster care for children in the provider's home, or foster care or daycare services for adults in the provider's home. So in 93, bars for a list of crimes that essentially corresponded to the permanent DQ list were created, along with 10-year and 7-year bars for the same category of licensure.
It essentially only applied to in-home childcare services, daycare and foster care?
Essentially, yeah. And so that system essentially continued into the creation of 245C. And it was only in 2005 that 245C 24 had the permanent bar language changed to just everything on the disqualification list, regardless of the type of licensure. So 2005, as you may recall, was generally when 245C was tightened up in response to the Drew Shadeen case. And since then, the only changes to permanent bars in 245C 24 have been essentially carving out exceptions to that general rule. So for individuals in the chemical dependency field, there's a possibility of a variance. For licensed foster care providers, there's a possibility of a variance. Let's see, non-emergency medical transportation services, and a very recent addition that took effect this year for licensed family foster settings. The 10
so,
and
can I jump in?
Yeah.
So the permanent bar starts off with foster care, then gets expanded to everything, and then we've had a few carve outs from that expansion, and one of them has actually been foster care.
It had. Well, let me read the precise language actually from what was passed last year. For an individual 18 years of age or older affiliated with a licensed family foster setting, excuse me, sorry about the noise, the commissioner must not set aside or grant a variance for the disqualification of any individual that's tightening up the family fosters. For an individual 18 years of age or older affiliated with a licensed family foster setting, the commissioner must not set aside or grant a variance for the disqualification of any individual disqualified pursuant to this chapter, regardless of how much time has passed, if the individual was disqualified for a crime or conduct listed in 245C 15 subdivision 4A. So that's essentially corresponding to the 4A is the new permanency list specifically for licensed family foster. But we also have attached to that the language, in connection with a family foster setting license, the commissioner may grant a variance to the disqualification for an individual who is under 18 years of age at the time the background study is submitted. So it's specifically for juveniles in that.
And that would be a child who is living in the home that's
with the mom.
Yeah. So yeah, that's essentially the really rough story there of permanent bars. It goes from a very specific set of licensure to general in 2005, followed by a few carve-outs. We also still have the 10-year and 7-year bar language on the books, specifically for the 90s era family foster categories, family foster and related category of licensure. I was just looking at the data we've received from DHS actually, and there are some 10-year bar disqualifications, bars. People end up in the system under the 10-year bar category, but it's a very small number. It was 27 cases in 2018 and 58 cases in 2019 out of thousands of cases in those years.
And some of them are for drugs, right?
Let me check actually, Ms. Evans.
Right, first degree, there's a 10-year bar for first degree, and that's federal or something, right?
Yeah, so sub 10s of the various CSCs in 2019, 11 for felony driving while impaired, terroristic threats, dangerous weapons, harassment, stalking, crimes like that are on there, but it looks like a lot of these are substance related crimes. So, yeah, that's sort of what I've got.
And I guess and maybe everybody else, to me, this whole bar scheme, like especially the 10, sorry, I gotta have it in front of me, the 10 and the 7. Well, it's weird because the statute is, I'll fully admit this 245C.24 is really confusing to me. It just seems like, why is this here? I don't understand the necessity of it when we're looking at Adam Walsh and all of the block grant and all of those. I don't even, it just doesn't even make sense to me. And then that we have a permanent, a 10-year and a 7-year and a 5-year. I don't get it. I'm going to be honest.
Yeah.
I don't get the use of it. The need.
I principally focused on the permanent bar and its evolution, but I got the strong impression the 10 and 7 years categories were essentially legacy categories. They have been around since the 90s and just sort of have been following this language ever since.
Yeah.
But one thing it seems like we're clear on is that the 05 expansion of the permanent bar, that was not something that was done sort of with the legislature's intent of like needing to comply with Adam Walsh or other federal laws. That was a political decision in response to the Drew Shadeen, and the public interest, I guess, the news coverage and all that, right? So because one of the things that we're thinking about is like how much of the permanent bar has to be there to comply with Adam Walsh. And it seems like maybe nothing, like maybe just going back to before the 05 revision would still comply with Adam Walsh, because then that's only dealing with the like childcare and foster care stuff that is the subject of that federal funding, right?
Yeah, I think so. Well, and I guess to me, and I guess people are open to somebody telling me that I'm wrong, but to me, when the Adam Walsh says permanent, that's permanent. When it's permanent is, so whether we have 245C.24 or we don't, like, to me, permanent is permanent. What's the point of 245C.24?
So I'm referencing this.
Mm-hmm.
What is it? Oh, yep.
2008. And so the thing that the 2005, the changes in 2005 did was, so they had it, the permanent disqualifications existed before 2005. The list of offenses eligible for permanent disqualification expanded. The change that happened was that the commissioner no longer had discretion to issue a set aside for those things on the permanent list.
Right.
That's what this says.
Right. That's what we're talking about when we say the bar is the bar to getting a set aside. But yeah, like permanent disqualification periods existed, but you could get a set aside for them.
Yep.
Except
Which I don't know that, to me, when I look at Adam Walsh and it says permanent, that means no set aside period. So to me, I guess I'm confused how they could have been granting set asides to permanent in the first place. It seems, I don't know that, I mean, well, at least related to Adam Walsh and the child care block grant.
Yeah, but didn't Will say that the place where the bar pre-existed 05 was in in-home childcare and foster care? And aren't those the things that are the primary subject of Adam Walsh?
Yeah.
So I'm wondering if, Adam Walsh compliance was basically the reason for the original bar for that limited scope. And then it got expanded to everything else when there was political pressure to do so. And so if that is the case, then, just opening it back up to allow set-asides for anything that doesn't conflict with Adam Walsh seems like a reasonable thing in my view. I might also even go further and remove it altogether, but just it would be the understanding that if DHS is setting aside permanent disqualification to a potential foster parent, that that the state is going to be forfeiting Adam Walsh Act money for that placement, I would think. But maybe we can look into that more.
Yeah.
I'll yield. I think Tashonda has her hand up.
Yeah, Tashonda.
Hi, everyone.
Hello.
Sorry, my schedule has been such that I've missed a few of these meetings. And I also want to say I've also kind of appreciated my schedule causing me to miss a few of these meetings. Full transparency, because it's just so triggering to hear. I mean, just to give DHS some credit, they're creating regulations off of a statute that all of these great minds here even feel is confusing, right, and antiquated. But yet people's lives are still being impacted by it. And Chair Dawson, I know we're going to get to the accountability part. I know that.
It's on the list, I promise.
Yeah, I'm just sitting on my hands, because I understand, I respect the process of it all. It's just really just saddens me just how unconstitutional so much of this is, and why there isn't an infrastructure assessment in place in all of these departments that deal with civilians, deal with constituents, whatever you want to name it, right? And then I also wanted to say that, excuse me, looking at whether the commissioner has discretion on this or that, I personally have had experience with the current commissioner and know that it hasn't necessarily been a great experience, just in regards to making decisions for what's right or for the good of the people. And I say this as a former chair-elect of the Cultural and Ethnics Leadership Council of DHS. And that's something we can always go, I'm always willing to dive off into if, you know, if any of that experience is pertinent. But just, you know, I'm done with my little rant, just to say we need to get to some type of infrastructure assessment when there's policies and regulations that affect people's day-to-day lives.
No, I hear you and I appreciate that. And I know, you know, yes, it's the accountability is for sure on our list. And I think part of our goal is to see if there's a way to simplify this process, ensure more due process, which in turn, I think in some ways, the goal would be to help address the concerns that you've raised about accountability of if there's more process and it's easier to follow and there's more due process, how that can potentially help. So I know we're trying to take a look at it all. And for us, I know at least this portion of it seemed like as good of a place as any to start. So no, thank you. Kind of now, so circling back to, so the 260 or sorry, I was working on some child protection stuff earlier today, 245C. I guess, I don't know, what do people think? I guess my interpretation would be these bars to set asides. Well, first of all, if the DQ subcommittee, as of right now, is really looking at more of a structure that is a permanent and a 5-year. I mean, to me, if we want to keep it real simple, it would simply be that this statute would need to be modified to be consistent with whatever those changes are. At a minimum. Or I think, Josh, you had even kind of suggested, does it go one step further and just say, eliminate it? Because especially if we're looking at where now somebody only has a 5-year bar, and it's really for your higher level offenses, do they really need that set aside process? Or, you know, something different, or is it, well, it's 5 years and it is what it is. And it was a serious felony. So it is what it is. I don't know. What are people's thoughts?
Say that what you just said again. Are you saying they have a 5-year bar and then they automatically get?
Well, if it's only a 5-year bar, at the end of your 5-year bar, you're done. You can apply and your DQ doesn't affect you. So do we need a set aside process if we're reducing the bar periods?
Well, I think if I understand, just looking at the statute here and Will's summary of his research, I think those non-permanent bars are also already limited to in-home childcare and foster care. Mm-hmm. So I think that makes sense with my theory that they're just there because Adam Walsh doesn't appear to allow, you know, any set aside, right?
Right.
And so we might be stuck with that to the extent that we want the Adam Walsh Act money. Does that seem right to people? And if so, does that address your concern, Chair Dawson?
Well, I guess my question is if we already have 245C where they're disqualified, and if the DQ subcommittee which is looking at those actual disqualifications themselves. I mean, to put it bluntly, what's the point if it's modified to say under 245C, you're disqualified for permanent, and it's a shorter list and it's only 5 years? What's the point of a set aside?
I'm sorry, can you say that one more time?
So if a recommendation comes out that it's being, the whole 245C is being reworked, and that we're looking at a permanent list and let's say a 5-year list or something along those lines, but it's your more serious offenses, your more your Adam Walsh type stuff. But more your felony level, some of those assaults, some of the drug offenses, some of the domestic offenses, things like that. That if it's going to be a permanent and let's say a 5-year, and they're really looking from the date of the offense, or if you go to prison, you're released from prison, essentially consistent with the new Foster Care Act. What's the point of a set aside? What is this?
So
That's my
basically,
question.
Lucas, what you're saying is like, let's get for instance, first degree assault.
Mhm.
It's a permanent bar. After their permanent bar of 5 years from release from incarceration, what happens then? Do they still have to go through the set aside process then?
Well, no,
That's
if
what you're
you,
asking.
no, if you've gone through your DQ period, my interpretation of you're done. I mean, if you have a 5-year DQ, if you're released from prison, let's say first degree assault, and let's say they move first, although I think first degree was still on the table for a permanent. Which means permanent is permanent is permanent. I guess that's my view, or that's my interpretation. That's where to me, if you're a child care and a foster care and all of that, permanent is permanent is permanent. So let's take the second degree, which I think there was conversation about putting that in more the 5-year. So if you're second degree, if you serve your prison sentence, you get out, you have 5 years. Once your 5 years are up, the DQ can't be used against you, period. That's statutory.
Yep. But what we're talking about right now is these bars, right?
Oh, there's an echo. Tashonda, I think, could you?
I was just gonna come on and just say real quick, that I think whether it's bars that we're looking at or not, that once that time period is up, that should be done, because we know that's the issue as well with people serving sentences, and then how do they acclimate back into society when that's being held over their head and they've served their time already. So it should be done away with once that time period has elapsed.
Yep, I
Yep.
agree. And that's the way that it is now. After 15 years, it comes off that's how it works now. After
Yeah.
15 years, that they stop asking about it.
Right. So that's where
Okay.
if now it's
Yeah.
reduced down to 5 years, do
Well,
we need a set aside process?
I think we
That's
still
my
do.
question.
I think we still do, because the bar to the set aside process only needs to be there for the narrow range of cases that fall under Adam Walsh Act. So for everything else, for our LADCs, for our people who work in residential care facilities, or for people who work in hospitals, all of those types of jobs, if I got a client who's got a misdemeanor domestic because they threw a pencil at their sister, I don't know that. I think they should be given the opportunity to make their case that it wouldn't actually be dangerous for them to work as an LADC
Before the 5 years.
before the 5
okay.
years. And then we
Yeah.
definitely need it for all of the permanents. A save maybe for the ones that have to stay, where we have to have a bar in order to stay in compliance with Adam Walsh.
Well, but weren't we, we were already recommending that for the permanents that, earlier on, we recommended that the permanents that are required for Adam Walsh and the child care block grant, and there were 2 others, and I'm totally blanking, that those had to stay.
Yeah.
But then we said that any other offense that we said it should follow the 2008 recommendations for the LADC and the in-home family services, where then it follows the 2008 recommendations, which I think are really limited to your higher level CSCs and your murder.
Well, in my ideal version of the policy would give everybody at least the ability to make their case that they're rehabilitated, even high level CSC and murder.
Okay.
That doesn't mean that it should be granted in all cases, but but yeah, I see what you're saying, that if we're already like basically eliminating the permanent disqualification period, then that cuts down the need to also allow set asides. But to me, just a sort of I guess the way I think of it is sort of the way I also think of mandatory minimums in criminal sentencing, where like this provision only does actual work when it prevents a judge, or in our case, an agency, from granting relief that they think is due. Otherwise, it doesn't do anything, right? Like the bar, if the agency is like, this person isn't rehabilitated, we think it's dangerous, then you have that individual discretionary decision maker making that decision that just sort of doubles up on what the bar would be. You don't even need the bar there. The bar only really like actually does anything when the agency would otherwise allow them to work, and the agency thinks it's unfair for the bar to be here. So, to me, it seems like the simplest and, in my view, the fairest policy is just to eliminate the bar everywhere we possibly can. And then that just sort of brings me to the question of, where does that leave us for Adam Walsh compliance?
Well, and so then it seems to me it would essentially be, eliminate the bar except where required by Adam Walsh, essentially. Because the hard part, even let's say Adam Walsh, where the other felonies are still, because Adam Walsh is really just felonies. And that's where I also think it's the child care block grant that brings in misdemeanor domestics. That's the kicker, if I remember correctly. And so, yeah, I think if there's a way to essentially say the bars are essentially consistent with those, and otherwise, what's the point? I guess that's just kind of, and that's, if we don't need, like, that's more work, that's more paperwork, that's people having to respond with it. And especially when I was like, at one point I was looking at the set asides, especially like a lot of those misdemeanor crimes. Set asides were being granted typically more often than not. So it's like, why are we going through that process? Why are we wasting time and resources?
Remind me again, what's on the block grant and Adam Walsh? It's murder, manslaughter, and criminal sexual assault. Is that what's on there?
The main ones are your homicides, your CSCs. They're all felony level. Anything felony domestic.
And did we differentiate about manslaughter? Did we figure that out? I
think, if I remember correctly, we ultimately determined it probably was still on there.
Okay.
And then, any of your felony domestics, but it's the child care block grant that specifically covers even misdemeanor domestics.
But what, at a 5 year, is that right?
No, I think it was still permanent.
Oh, really?
Yeah, child care block grant was not friendly to misdemeanor domestics.
Well, I agree that there shouldn't be a need for set aside if that time has been, if that time has passed in regards to the bar, or whatever is set, that the person shouldn't then have to go and get a set aside when they've already had that time.
Yeah. And I think that to me is statutory. And I know, that's definitely been one where people call and I sit and do the math and count as to when it should and shouldn't be there anymore.
And, that's another recommendation maybe too, that people are provided the date that their time expires, if you will.
That makes it a little bit, because I think right now you get the letter and it just says you're disqualified.
It does say, I think it does say the disqualification period.
Does it? Okay.
But it'll say, it'll be, the information will be in different parts of the letter, and in one place it will say you're disqualified because on, April 1st of 2020, you were convicted of a misdemeanor domestic assault, and then somewhere else it'll say it's a 7-year ban. And it probably isn't clear whether that period is going to start from the date of conviction or the date of discharge. So I really like that recommendation that the notification letters spell out.
I can't remember what it was we were looking at, but there was some confusion in regards to that start date. So being able to specify when it ends will alleviate a lot of confusion as well.
Yeah, I like that.
So Lucas, can I bring it back to something you were saying about, especially when set-asides are being granted at a high rate, sort of what's the point of this process? And I wonder if you can, I guess I'm unsure a little bit how that sort of fits in to our discussion about what the remedy available should be. Because on the one hand, if we're already reducing a lot of the disqualifications, then there's no need for a set aside. And to me, that lines up with your point. Like it seems like that observation is an argument in favor of just getting rid of some of these disqualifications altogether. But it's a separate question of when the disqualifications that are still in place, should there be a set aside remedy?
Right.
Am I understanding right?
Yeah, and I think your point about the domestic, where, I mean, obviously we know for the childcare block grant and stuff like that, there are issues there, but like your point to the domestic, I think was a good one that I hadn't really thought about. And I do see where if some of those offenses are still going to be on there, it makes sense. And I think more where I was even thinking is when I say the set asides are granted more often than not, it just seems like, I don't know where I'm trying to go with it other than to say, well, I think it definitely weighs in favor of why are they on the DQ list in the first place? If a set aside is just going to be granted, why is it there? But then secondary, it just seems like the set aside subdivision or statute, if it can be simplified in some way or an easier process, or I don't know. It just feels like there's this work for it. And if we kind of all know how that outcome is going to happen, what can we do to why make it hard? Like, why can't we make this simple? I guess that's my, and that's where this whole like 245C.24 is just, for me, it's confusing.
So it seems like a big kind of elephant in the room for us is not knowing exactly what the DQ committee is going to recommend as being on which as which crimes are going to create disqualifications and for how long, right?
Mm-hmm. Yeah, that has not been finalized yet.
Well, I mean, I guess either way, though, we know we're going to have some stuff that's going to be a permanent disqualification and some stuff that's going to be something less than that, seemingly a 5-year disqualification. It may be that lots of things that used to be disqualifiers just no longer matter at all. Mm-hmm. But that doesn't really change the fact that some things will still matter. So, maybe for our point of view, we just really focus sort of on kind of the process side. In terms of the bar, I guess my position, just to reiterate it, would be it doesn't make sense for anybody who is subject to a disqualification to not have the opportunity to ask for a set aside. And then limited only by the fact that the state could lose federal funding if it granted set asides for some people if that violated the child care block grant or the Adam Walsh Act. One question I have about that is whether that funding is premised on like all the entire system working in a particular way, or whether we as a state would just lose funding for like a particular foster placement if that particular placement didn't comply with Adam Walsh. Like, could we make a decision about granting a set aside and have it factored into this decision that it would cost the state more money to do this foster placement?
Ramsey County is doing it right now.
Okay.
Ramsey County is doing it right now. They're foregoing the federal portion of foster money in order to place kids with family members that they know is going to be a better fit for them, instead of taking the federal portion of the money. Ramsey County is doing it right now. And people who, what's her face? Who's the new person that used to work at DHS? She doesn't agree with it. So there are counties that are doing it right now. I don't know that as a whole, that's gonna go. I mean, that's not gonna go over well, like a recommendation that we don't take federal money in order to do this. So just.
Do you know, like?
Excuse me.
You know,
Excuse me. Chair Evans, could you speak a little more to this? Are you saying that the state receives more federal dollars when a child is displaced out of their home and they're displaced with a stranger versus with their family, that the state gets more money for that? Is that what you're saying?
No, I'm saying that Ramsey County right now is making placement decisions to keep kids with family members, and they are not tapping into the federal dollars in order to do that.
Families that might otherwise be disqualified.
No, I get what you're saying, that Ramsey is doing something innovative, but I'm just saying the status quo had been where the state would receive more federal dollars for children being displaced outside of their family.
Well, their families are not, they are disqualified because of the work that we're doing right now, because they have criminal convictions and aren't able to be placed because of those criminal convictions. And so, I mean.
And the state is getting more money to follow suit of people being disqualified, as we know, for heinous reasons and constitutional reasons, and then the state is getting more money for that, meaning
the state does not. Yeah, no, the state does not get more money if it's relative or stranger foster care. I think there's a whole, formula for it, but it's not more. The only time that there are no foster care dollars is when children are placed with the other parent. The other parent does not get foster care dollars, but a relative would still get foster care dollars. So the financial piece is not the same, or not different.
A relative gets half of what a stranger would receive. And I know that firsthand. I mean, this is just ridiculous that so much is motivated behind money. Wow.
Well, and if I may, that's sort of what I'm thinking is like, I like what Ramsey County is doing. And I get that Gina's point that like, there's going to be a ton of pushback from the state legislature if we try to force what Ramsey County is doing on every other county, but maybe a compromise is to just say that if a county wants to grant a set aside, for something that has Adam Walsh or child care block grant financial implications, they can, They just need to know that they're giving up money that they would otherwise get from the federal government to do it and need to make it up elsewhere.
And it would only be for foster care, and like if it would be, like, I feel like they're using those rules for everyone around the childcare and foster care stuff, right? So those,
Right. So I think
those rules don't apply for.
I'm already suggesting that we
Right.
get rid of the permanent or the bar on set asides for permanent disqualifications, that we get rid of that for everything that we can that isn't related to childcare. And then my suggestion B would be that we explicitly allow a set aside for a childcare permanent disqualification. But we make it clear, either through the statute, or maybe we even say in the statute that a justified basis for denying this set aside request is so that the county maintains its Adam Walsh Act funding for this childcare placement. Right. So we could even make it so that if they want to, they can just come back and say, no, even though we think you're rehabilitated, we can't do it because we can't afford it without this federal money. But that at least puts the power in the hands of either the county or DHS itself, to start granting these set asides if they can make up for the cash deficit. And maybe even that's something that goes into consideration with the foster applicant, right? You can still foster your family member, but you can't count on this federal subsidy to help.
Well, and if you think about it, think about families who go into family court and get third-party custody. There's no background check of, what's the family court system can do a full analysis as to which placement is better for the child. And don't get me wrong, if you've got some serious felonies on your record, the family court will at least probably have to take them into account, but you're not getting payments for it. You're agreeing to take niece, nephew, grandchild, whatever it might be, for nothing. I mean, so family court's kind of already doing it, if you will. So no, and I think that's a good idea. And I think it would just be probably figuring out how we'd want to write some of those. I mean, I think we have a lot of ideas. I think we have a lot of ideas of how to improve 245C.24. And I think some of this, to really finalize it, we need to really know what's going to come out of the DQ subcommittee in case it shortens up what our recommendations may be, or makes it longer. I think it just depends. But I think, with that, I think we have a lot of ideas here, and I think we all pretty much agree eliminating the bar wherever we can. Really, I guess people speak up if you disagree. Really trying to allow set asides for, that would be consistent with whatever the DQ subcommittee ultimately recommends. And then even building in some discretion for the agency, understanding they could end up foregoing federal dollars. I don't think no agency is going to forego the child care block grant dollars.
Ramsey County is.
Well, but that's Adam Walsh, not the child care block grant.
Okay.
I think child care is going to stay. I'm guessing. So to me, it would really be to allowing really families to stay together, which I think is pretty consistent with what our recommendation had been for the family caretaker option of this is your family, you're in the home, and you're better suited, if we can keep the children with their family, that's really better for them. Now that'll take a shift in the foster care process, in their thought process, but I think this is a good starting point and could have some good effects on the child protection system.
It just seems so, I'm just hearing about with the funding, it just seems very motivational to not find qualified family members because there's more dollars to be gained with these children being displaced. Wow.
Agreed.
Yep. No, and I think I'm not as familiar with the number side of it, but I know I have heard a lot of the mentality about if there's a problem with the parents, the apple doesn't fall far from the tree. So therefore it must be related to the entire system, which is troubling. So I think as a whole, though, maybe that some of this can allow to maybe start to shift some of those. I think it, and then obviously on the employment side as well, allowing people to maintain their jobs and continue doing what they're doing or get back into work.
Respectfully, I say that's BS. Because there is not motivation to find qualified family members and to say the apple doesn't fall far from the tree. How many of you everyone got sickos in their families? And we already know the data shows that this is happening primarily to Black and brown families. It's
No, and Tashonda, I 100% agree with you. And of course, those are the arguments I'm given from child protection workers. And I see it on a daily basis. So yes, the system is broken and there needs to be changes.
No, the system is working by design. Trust me when I say that. Okay, I'm done.
Well, actually, Tashonda, can I just ask? Because I think all of us are, in agreement that whether broken or working exactly as intended, it's not working the way any of us think is fair or just. But from our point of view, we've got this pretty awesome opportunity to change, the background check process itself, but we don't have any control over, say, like what the federal government decides they will give money to the states to subsidize. So, given the limitations of what we can recommend, how do you feel about what we've been talking about? Which is eliminating the bar to seeking a set aside basically as much as possible, even including as it would apply to foster care.
I'm in total agreement to make it where it's not so cumbersome for a person to be able to live their life with the American dream of liberty and property, right? So yeah, I agree. Whatever we need to do to remove those barriers or remove those additional actions that people need to make, we do it. And I get that our task force isn't going to necessarily just make everything perfect and right. I get that. It's just really alarming. The deeper and deeper that we go into this, what's coming out of it is just so alarming, so triggering, so disappointing.
Yeah, agreed. I just want to make sure that I understand you when you're expressing this frustration, that it is you're expressing frustration with how the system at large works, and not disagreeing with what we are.
I'm not disagreeing with the work that we're doing, and like I said, I respect the process. We have to go about this systematically. So a lot of times I'm just kind of this is a space to just vent in a sense, because so often the numbers, the paper has been looked at and not actual people's livelihood, humanity hasn't been viewed. So it's a way of me to just express that humanity of what we're finding. and trying to combat and change. So, but no, I am in agreement with what we're doing.
Awesome.
Thank you for that clarification.
Yeah, no, and thank you. And
For requesting that
I
clarification.
thought that was the case. I just wanted to make sure. And I do think it really is important that we take, even if that's something that we can't fix, you know, I think this is a good place to define problems, you know, and make a record of it. So I appreciate your contributions, and I'm glad that we are on the same page.
Me too.
Yes, thank you. Thank you.
All right, so as far as 245C, just sort of 0.24 in general, I feel like we've got, you know, a lot there. I think a lot of, and I think similar to what our recommendations have sort of been shaping up of, you know, we're not at that writing phase where we're specifically striking out portions of the statute or anything like that, but we're really kind of coming to these more big picture, broad stroke recommendations. Unless anybody feels otherwise, I feel like we have some good ideas and some good thoughts for this statute. Obviously, we need to know some more final pieces from the DQ subcommittee, but we're at 11:55. My thought would be, if people feel like we're pretty good here, let's move on next time to a different portion of our conversation. And just looking back, just getting to my notes here. Josh, I know you were going to be looking at some of the expungement piece, and then we also need to look at the actual appeal process itself. And Josh, I know, oh, here it is. You were going to look into kind of clarifying who actually gets a hearing and who doesn't. So those were kind of two, but I know they were yours, so I don't want to overburden you. Our next meeting, would it make sense to move on to either one? I'm open to whichever one people want to move on to.
That's fine. Yeah, why don't we do expungement? I think that is, well, the one thing one thing we had sort of identified that we were going to maybe ask DHS for some input on was what their internal process for determining when they object to an expungement is. I don't know if, I think we can talk about expungement without having that input.
So I'm doing this right now, my expungement stuff. And I can tell you this about that. I got a Ramsey County expungement this year and a Washington County expungement this year. And I'm working, my Scott County stuff is going through the courts right now. And I went down and got another copy of my BCA report, and they're not even getting taken off of the BCA's report, let alone the DHS's report. And so there's something wrong with the process, Josh. And so I'm working through it right now. Like, I got all my paperwork together. I'm going to bring it back down to the BCA to have them remove it from there. But if the Attorney General's office and the counties that are doing the reports themselves, like, I feel like what's happening is that they're reporting when they do they report to the 8 different people with the initial like request or whatever, that they're doing it. But then when it gets approved and the courts are sealing the record, that it's not then getting re-reported out to all of those places.
Okay. So there's a bunch of like pitfalls in the expungement process that I wonder, I would be more than happy actually to take a look at that stuff and help you navigate it. But I wonder if that actually might be separate from what would be going on with DHS, because I have heard problems about that. And I think also, well, I won't talk about your specifics. Let's talk about your specifics offline.
Okay. We can talk about my specifics, though. I don't care if we do.
Oh, well,
I mean, if it's helpful to, I mean, I just feel like.
I think
the
I
fact-
just think you might be in a really unique situation because you've gotten the pardon.
Oh,
That just doesn't apply to most people getting an expungement. Most
Yep.
people, so few people get pardons. That
and I am working right now on a bill to have it be an automatic expungement after a pardon. I met with Senator Limmer last week. To talk
Whoever
about
wants
it.
to do that. All right.
Um,
Okay.
And I think back to the expungement, sorry, just question really quick. Will had sent all of us an email on August 11th. Because remember, we had sent over the request and they responded with the whole Katie Ryan had presented on it. And are there additional questions to that? And I know.
I'm sorry, Chair Dawson. I respect you all and appreciate all you're doing. I do got a hard stop at 12,
Okay,
so
that's
see
fine.
you all later.
Yeah.
All right.
Bye, Tashana.
Bye.
Bye, Tashonda.
And Madam Chair, I actually just re-forwarded that email to everyone, so it should
Got
appear in
it.
your inboxes.
So. I think I don't know if we just need to maybe firm up, because I know, Josh, you and I had looked at the presentation when putting together the questions, so we had already done that.
Yeah.
Um,
Why don't why don't we plan to talk about expungement and see if we can come to a consensus on what we think the recommendations would be.
Sure.
And if we feel like we need additional input from DHS after that, we can ask about it. And then the other issue that I've been doing some research on is trying to navigate who ends up in front of a DHS judge versus who ends up in front of an administrative law judge.
Okay.
And I'm still working on that.
Well, then should we plan for expungements next time?
Yeah.
And then that'll give a little bit more time. And I think expungements should be kind of like this one, where it's probably one meeting. We're actually just focusing on it and we're done. Whereas I think the actual process might be more than one, would be my guess.
Yeah.
That's
That question about which set of judges you go through is more tied to sort of the nuts and bolts of the entire process. So I think that sort of fits in as a subset of that part of the discussion anyway.
Are you going to put together a nice little presentation for us on when, like, your path of what goes where?
I don't know. It depends on if I can wrap my head around the whole thing in the first place.
Okay.
But maybe.
All right. Okay, so I think that sounds good. So our next meeting is September 12th. I will warn, I am technically scheduled for a TPR trial that day. It may resolve, but I just don't know yet. So if I'm not here, obviously, Josh, if we're gonna be talking about expungements, if you wouldn't mind leading.
Yeah. Oh crap. I've got a jury trial scheduled that day too.
Oh, well, do we want to look at instead moving that meeting? I don't know to when.
The 5th is Labor Day.
Mhm.
I could do the 6th.
I'm wide open that day.
That's not a good day. Unless, I guess, could we be ready with it by next week?
I'm at the fair.
Okay.
I mean, we could keep it and just hope that neither of our trials go.
Mine, I'm supposed to have a settlement call on Friday. The judge has already given, I think, his views, hopefully will settle. But it is still technically on the calendar.
Mine, I will.
And I can definitely, I mean, I should know then by, that week before, I can shoot an email to everybody and I guess let's all keep in contact, and if for some reason we're both in trial, maybe then we'll look then at rescheduling. So maybe let's keep it for now and see how all of our calendars shake out.
Okay.
I have Tuesday, the 30th wide open. I don't know if either of you do.
Tuesday, I would in the morning.
So for me, well, actually, if we put it on there and my case ends up going, I could ask to not start until Tuesday afternoon and do the meeting first.
So do the meeting on the 12th, you could ask to go on Tuesday? Is that what you're saying?
No, I'm saying, well, actually, no, I think we should be fine. I should be fine for the 12th because mine is a misdemeanor cattle call.
Oh,
And so, you know, even if my case goes, I actually probably will have open time from 11 to 12:30 that day. So.
okay. Perfect.
Okay.
Okay. Yeah, and I can just keep you all in the loop, and we'll see what happens.
All right. Sounds good.
All right. Sounds good. Thanks, everybody. Thanks for staying a little bit late.
All right, guys. Hey, Gina, do you want to call me quick?
I do.
Okay.
Okay,
Bye.
perfect. Bye, everybody.